Hi, good afternoon, folks. This is Rajiv S. Khanna from immigration.com, the law offices of Rajiv S. Khanna, PC. This is a call we hold every other Thursday on a private call where all folks who want to have their questions answered are invited. We encourage you to place your questions in the forums.immigration.com spot where we have designated where you can post questions ahead of time, because the posted questions will be answered no matter what. Time remaining, we will answer other questions. I intend to start holding every other Thursday audio calls on LinkedIn, and then the second Thursday. So in other words, every Thursday there will be a conference call, once on our private conference facility and once on LinkedIn. The reason I like the private facility is because, as far as I can tell, you're completely anonymous. Unless somebody subpoenas the information from me, there is no way for your privacy to be violated. On the LinkedIn, everybody knows who you are and you're asking questions. But if you're comfortable with that, of course, there is no problem. Now, remember, this does not create an attorney-client relationship. This information is provided as is, no guarantee about anything, because we only have basic facts. Okay, so I'll go over the questions, and then each time I answer a question, I will invite you folks to ask follow-up questions. Okay, to ask me a question, all you have to do is press *5 on your telephone. When you press *5 on your telephone, I can see that you've raised your hand, and then I'll call upon you and answer your questions to the best of my ability. But these are only follow-up questions. No, ma'am, put down your hand. Right now, I'm not asking for questions. Put down your hand, please. Press *5 again. Okay, I'll put it down for you. Thank you. So right now, I haven't even started the conference call. Once again, I'm going to do a sound check just to make sure everybody can hear me okay. So let's see. Can you guys hear me okay? Hello? You know what? I can't. Let's see. Back to conversation.
The conference is now in conversation mode.
Can you guys hear me okay? Everybody can hear me fine? No problem? Hello?
Yes.
Okay, good. Thank you. All right.
The conference is now in presentation mode.
Okay, so let me start the questions that have been posted. A recording will be posted within the next couple of days. Let's begin. The first question was about a religious minister working on R1 visa. So they want to know, am I eligible for another R1 extension? There's a whole lot of facts which I'm not going to go through. So R1s are, from what I recall, only given for a total of 30 months in one stay in the United States. So if you have received a little bit more than 30 months, that's must be USCIS calculation. I don't have any problem with you using that, but you cannot get extension beyond the initial 30 months or 31 months, whatever they've given you. After that, you have to leave the United States for 1 year, and then you can reset the time period that way. There is some overlapping. I'm not sure what happened there, ma'am. You have too many facts, and I don't have enough time to go over each one of them. But this kind of an overlap, if it amounts to 31 months, so be it. But overall, your period is only 30 months at one time. Currently, I'm being paid a monthly stipend, but it's less than what is stated in the initial R1 petition. I've taken a vow of poverty. My expenses are very minimal. So as long as you can explain this, I requested health insurance from my employer. He agreed to it. Yeah, I think so. I think you can, because if you look at an R1 petition, a religious worker petition or minister of religion petition, it says, what are you getting in cash? What are you getting in kind? And personally, I think that you can have this issue researched. I don't know off the top of my head, but you can certainly have this issue researched. But to me, it doesn't look like any of this is unmanageable. Okay, so because both cash and kind compensation counts, and you can explain the fact about vow of poverty, and that you're not allowed to live in the lap of luxury. That's your sacred oath to your maker. I think that's okay. I don't see why not. If anyone has a follow-up question on this religious visa issue, press *5. No new questions, only a follow-up on what I have discussed. Press *5. Okay. Next question. Errors in the I-140 approval on the employer revocation period for visa change, which approval date to consider? Okay. So what has happened is my I-140 was approved in September 2022, but it contained errors on employer's name. Instead of employer's name, my name was printed with incorrect spelling mistake. Which approval date should I consider for counting 180 days? The date it was first approved with errors, or the date it was approved with corrections? So that's a very difficult question to answer. I think the errors are minimal. They don't appear to go towards the merits of the case. The case was clearly approvable. So it depends, Bhargavi, how aggressive you want to be. My recommendation would be to be very conservative and consider that the date of the final approval is the beginning of your 180 days. But if you had to be aggressive, I think a case could very well be made that 180 days began on the first date of approval, because the approval was essentially accurate except for typos. Okay, so there is the aggressive interpretation and there is the conservative interpretation. Your choice. I advise conservative. *5. If you have a follow-up question, press *5 on your phone. No new questions, only a follow-up on what I discussed. Okay, let's go on to the next posted question. I'm actually on our website, forums.immigration.com. If you want, you can go, but I'm actually recording the screen as well. Next question is, returning to the US without a project after traveling to India on advance parole on Green Card EAD, document requirements and consideration. So I received my Green Card EAD. I'm on H-1B. My project ended. I'm in between projects. I would like to spend some time with my parents. What documents do I need to carry? While traveling back to the United States, if I'm using my advance parole, will there be any issue since I'm not in a project, but working for the same employer? So Srini, one of the things that I would do if I were you, I'm assuming that it's over 180 days because you received your EAD in 2022. So your I-140 is approved. Your 485 has been pending more than 180 days. You are also covered by AC-21 portability rules. So if I were you, I would travel, use my advance parole, but I would also carry, if not a letter from the current employer saying they have the offered job still open for you, but also from perhaps another company that says they can offer you a same or similar job, just to be safe. Ideally, if you can avoid traveling altogether and just stay in the United States, that would be perfect. Okay, so that's what I would recommend. *5, if you have a follow-up question, no new questions, only a follow-up. *5, press *5 on your phone. Okay, go on to the next question. Once I'm done with the posted questions, then we'll start with new questions. Okay, at about 1 o'clock Eastern time, which is in about 20 minutes, I'll close the conference. That way we don't admit any new people. I just make sure that everybody who's here, their questions are answered. Okay. So here is the next question. F1 OPT and working for my father's company in India, legal considerations. So if I am on F1 OPT and my father has a software company in India, can I legally work for his firm? You know, on first year OPT, my guess would be yes, because first year OPT is quite flexible. And your degree that you finished is in something to do with software, computer science, information management, you'll be working in your own field. You can double check this with your DSO, but personally, I can't see why not. First year of OPT. Technically, you're supposed to only work for US employers. But here, even though you are on the US soil, you already have an OPT that you're working on. This is just additional work. I think it should be okay. Press *5 if you have a follow-up question. press *5 on your telephone. Okay, no new questions, only follow-ups right now. Next question is, bringing parents to the US on H-1B visa. I have a very detailed discussion on this. This is in our frequently asked questions. You can go check it out. But the basic idea is, sometimes some people don't qualify for a derivative visa like H-4. Such include people like your parents. Your wife qualifies, your children qualify, but not your parents. So there is actually a provision in the Foreign Affairs Manual which says that in such cases B2 is a good choice, and it is allowed. It used to be used a lot when gay marriages were not recognized in the United States. Gay couples used to arrive using this provision where you can have family members arrive on a B2 and then keep extending their B2 if their presence in the US is required. For example, they have nobody to care, they have medical need or emotional needs. We have done these cases before. It seems to work so far, but ultimately it is the discretion of the government. The provision does exist for these long-term extensions. Press *5 if you have a follow-up question on this. I'm just going through the questions and then we'll open the floor for new ones. Okay. Sachin Saini says, F1 visa transfer and extension. Can I travel to India and extend my F1 visa? I'm an F1. I came to the United States at Castleton University in 2022. Then I transferred to a language school. Oh, that's a problematic case. Then you transfer to, is it CUNY? LaGuardia Community College, and I take one semester and transfer into language school. See, I think your case is tricky. Now, I could be wrong about this because what you told the government when you first got the student visa seems to be a little bit in contradiction to what you are doing now. So if I were to make a guess, again, I'm not God, I can only predict your chances knowing what I do know. I think you could have a problem getting a student visa because they could say it doesn't look like you have the intention to be a genuine student. It looks like you're just whiling away time. Okay. *5 if you have a follow-up question. No new questions. *5 if you have a follow-up question. All right. Next question. This is probably, somebody raised a hand. Okay, let's see. From Texas. Texas, go ahead. I can hear you.
Yeah, Rajiv. So here's the case: like my 5 years of visa is getting expired in October.
Okay, that's a new question. That's a new question. No, not right now. Wait until I ask for new questions. Please don't do that. I'm only asking for follow-up questions. So the next one is H-1B lottery. Can you join employer B after being picked by employer A? Okay, I had 2 full-time job offers. Both the employers, unrelated, filed for lottery. If I get picked up under the name of company A, can I join company B? Oh, absolutely not. You cannot transfer lotteries. No, sir. But you can, after you are approved for the H-1B, on or after October 1st, you can transfer the H-1B. Okay? *5 if you have a follow-up question. Nothing new if you have a follow-up question to what I discussed. Okay? Next question is switching employers on H-1B visa. Can an approved for-profit H-1 be reactivated after withdrawal? Yeah, I think so. Let's see what your facts are. I was employed by a non-profit company. Then I have an H-1B visa picked in the lottery and approved in 2022, but not activated. So the question is, what is activation? Activation can simply mean approval with a change of status or approval with a visa stamp. If both change of status or visa stamping is not done, can you still activate it? I think you can. Government says you cannot, but there is really no legal ground for that. So we have done many of these cases in the past. So far, they seem to be working out. So it's worth a shot, but don't depend upon it until you hear definitively from the government. Okay? *5, if there's a follow-up question, *5. All right, this one is, let's see, from New York. Yeah, New York, go ahead, I can hear you.
Hi, Rajiv. This is Bharat. So, from activation in the sense, I never used that H-1B. I mean, I never started working to that employer.
Okay.
Just take that
So stop for a moment. Stop for a moment. There is no law that requires you to actually work for the company before you are considered to be activated. Okay. If you received an I-94 with the decision, or if you went and got a visa stamp, then absolutely 100% there's no problem, as long as that H-1B was not withdrawn or revoked before October 1st of that year. Okay.
Okay, it's not revoked or withdrawn. Yeah.
Yep.
So,
all right. Good luck.
Thank you, Rajiv.
You're welcome. Yeah, the laws in this area are so complicated, and government they try to do the best they can, but there are so many permutation combinations of events and possibilities. Next question, Sriram, completing DS 160, filling in father's surname, given name, and middle name. Applying for an F1 student for fall 2023. So, if my father's name was Rajiv, if on the passport father's name is mentioned as Khana Rajiv S, but actually the name is Rajiv S Khana, what should I do how should I fill out the DS 160 form? So this is the way I see it. Now I do not know if this is precisely the correct advice, but this is the way I would do it. I would fill out the form DS 160 as is absolutely accurate. So I would fill out first name Rajiv, middle initial S, last name Khana. I don't care what the passport says. This is the way I would fill it out. Okay? *5, if you have a follow-up question on this, *5. Vaibhav 31, L1A to EB1C, can multiple visits to the home country be combined to meet the 1-year requirement? You know, this is very interesting question. I don't really know the answer to that question. I know it in the context of an L1. It's something I was looking at only recently. I was always of the opinion that you have to be outside the United States for 1 full year to qualify as under L1A. But there is some mild and small little exception to that. And in one case, the guy worked in India for 7 months, but then came for training for the same job for 5 months to USA. And for some odd reason, the Administrative Appeals Office said, that's okay. And that case has been cited as recently as 2012. That case is from the 1970s. So there may be something, have your lawyers look into it. There may be something there that might help. So the answer to your question is, there is something in the law that should be looked at. If you had asked me last week, I would have said no. That's probably not going to work. But that's why we always check and double check everything that we think we know. So have somebody look at it, okay? *5, if there's a follow-up question. I don't know the answer offhand, but I know there's something that we should look at. Let's see. This one is from area code 718. That's New York. Yes, New York. Go ahead, please.
Hi. Just a follow-up question on this. I just wanted to understand on the L1A or the EB1C, how easy or difficult is it to get a functional manager case approved against a manager having direct reports?
That depends. If you are truly a functional manager, you will fulfill the following requirements. Number 1, you will be in a fairly high position of decision-making authority with regard to a function. that function should be essential to the company. That function should actually be separable. You can separate and say, this is the function. Okay. So these three things, when they exist, high discretion and authority, essential function, and discrete function, something that can be separated, we can get functional managers, absolutely. But as a practical matter, it is usually easier to do people manager than functional manager. Okay, usually.
Okay.
All right.
Okay, yeah, that was my question. So having direct reports is more of a easier case than having being a functional manager.
But that doesn't mean that you should,
USCIS.
Yeah, that doesn't mean you should give up on functional manager. I just don't know all the facts. I think these cases are possible.
Okay.
I have, in the last 20 years, I can't remember ever losing a functional manager case. We've done several. Before 20 years, I don't remember. But last 2 decades, I remember. Okay. I don't remember the cases I have won, or the firm has won, I should say, but I do remember cases that we have lost. So if we have lost a case, that sticks in my mind forever.
Okay.
All right?
Okay.
Good luck.
And when you do come back to the US, just a follow-up question on this. Like, when you do come back to the US, assuming you have a H-1B, but you come back after a year.
Yes.
So you don't really need to come back on L1A, right? You can come back on H-1B. Like, these are treated as independent cases.
You can. I have a client who's coming in from Europe right now. We have his EB1C approved, but he also has an H-1B approved. So he's using that H-1B to enter. And once he gets here, we'll do the H-1B amendment to reflect the higher job.
I see. And when he's entering the US, does the organization have to create a new role for him?
No. They will, look, so let's say he was approved for a business manager, section manager, he was managing a unit manager, but then he gets promoted to director. His H-1B is as a unit manager. He comes in, he starts the job as a unit manager. When we file for his amendment, he can start working as a director. You see?
I see. So the amendment needs to be filed in any case.
If there is substantial difference, if the two jobs are pretty much similar, you don't need to do an amendment.
Okay. And you can do concurrent filing at that point.
Yeah, you can. You can. Why not? Each case is different. I'm giving you general guidelines. Okay?
Got it. Thank you, Rajiv.
Good luck, sir. Let's go on to the... So this was your question. There were more. Hang on. Let's say I go to India for 5 months. Oh yeah, we already talked about that. Okay, so... if I get L1A stamp, will they cancel my H1B stamp? Normally they are supposed to, but as a practical matter, they often do not. Okay. So if you look at the standard operating procedures, I think there's somewhere there that says you should cancel out the existing visas and then consider the visa application. But that sounds a little weird. Why would you want to cancel a tourist visa or an H-1B visa if you have not yet granted the L1? So the answer is they may by their SOPs be required to, but as a practical matter, I've never seen them do it. I've never seen them cancel existing visas. Okay. Next question is, we are coming to the end of the posted questions. H-1B and green card EAD, can you work for a different company using EAD while maintaining H-1B status? No. Once you start using your EAD, H-1B has gone to sleep. To awaken it, you've got to go outside, get a visa stamp and come back. But once you start using your EAD, you are on EAD. EAD and H-1B cannot survive together. Okay. *5. If you have a follow-up question, press *5. Okay. I think this is the second last question. Yeah. Second last question. I have no idea what the Capstone project is. I did not pass my e-portfolio Capstone. I have no idea what this means. Are you on the phone? I don't even know if this has anything to do with Capstone Project. If you are on the phone, press *5 because I don't understand the question. What is a mandatory e-portfolio? No clue. Never heard of it. You're not here? Okay. Last question. Can you work on Green Card EAD after quitting your H-1B job? Yes. Do you need to move to H-4 and apply for H-4 EAD? No. The 485 EAD is pretty strong. I like 485 EADs. Do I need to move to H-4? You do not need to move to H-4. It will be nice if the H-1 holder can maintain their status. They shouldn't use their EAD, but you can use your EAD without any problem. But again, if the H-1 holder has to use their EAD, so they do, no big deal. But I prefer to have that extra cushion of an H-1B. Okay. Star 5, if anyone has a follow-up question on these couple of issues that I just discussed. Okay. Let me close our conference so I can make sure we get all the new questions. I'll take just a 1-minute break to go get some water. Give me just a moment. Let me lock the conference.
The conference is now locked.
Okay. Let me just pause the recording for a moment. I'll go grab some water. Okay, folks, I am back. Let me just run a sound check one more time. Give me 1 second.
The conference is now in conversation mode.
Do I have to talk to the kid?
Can you guys hear me okay, everyone? Can you hear me all right?
I'll be here on it.
1 second. Can you all hear me okay, folks? Can you all hear me okay? Hello?
Yes.
Okay, very good. Let me go back to resume the conference. Give me 1 second. Okay, here we go.
The conference is now in presentation mode.
Now, anyone who has any question, press star 5 on your phone. Anyone who has any question, press star 5. So far, 8 raised hands, 9, 10 raised hands. Okay. So I will take you in the order that you logged into the call. So 11 questions, okay, 11 raised hands. All right. So no worries. 11 I can do in my sleep. No problem at all. So let me begin with Kansas City. Kansas City, go ahead, please. I can hear you.
Yes, that's me. So my name is Masira. My question is based on USCIS rule that came out January 25th, where they said that if H-4 and H-4 EAD is bundled with H-1B transfer in premium processing, the processing of all these 3 visas will be done in 15 days. Is that practically true, and what are the limitations? And a background, I'm on S1, so if my husband was to do my H-4 and H-4 EAD, then it would be S1 to H-4.
Yes. So this rule was the result of a settlement in a litigation, because the government realized that they probably should want to settle the case. And the settlement said, if you bundle an H-1B premium processing with the H-4 and H-4 EAD, we will decide the case under the premium process. That doesn't mean you'll get it in 2 weeks, but it just certainly means that you'll get it in a matter of weeks. What if there's an RFE, right? So if there's an RFE, that'll take some extra time, but you will still get it in a matter of weeks rather than months. So is this true? Yes. Is it doable? Yes, we are doing it all the time. So definitely, it's a good way to go. Does that answer your question, ma'am?
And sorry, I just have a follow-up. Is biometric required for this?
Oh, that I don't know. I'll have to check with somebody in my office. No idea. Okay. Yeah. So when you file, your lawyers will check on all that. Don't worry about it. I don't remember I don't even remember if they have H-4 biometrics anymore. No idea. Sorry. Okay. Good luck.
Thank you.
You are welcome. Let's see, what do I need to do here? I think I need to say skip. Yep, that's what I needed to do. Okay, Kansas City is done. Now we have California coming up. 1 second. California. What number am I looking at? 707. Just 1 second. California 707. I have a bunch of people from California. This is the one, I think. California area code 707. Go ahead, please. I can hear you.
Hello. So I'm in a similar situation to a question discussed earlier that I'm currently working 2 full-time jobs at 2 companies under F1 OPT. Both companies enter me for the H-1B lottery, and one got selected, the other one did not. So one company is filing a petition for me. So my question is, for now, until the H-1B started October 1st, can I keep working for both employers? And will that affect my H-1B condition?
Okay, so there are 2 different aspects to it. One is, how long is your current OPT valid? When does it expire?
Expiring January next year.
So you should have no problem, right? Because until October 1st, you are on OPT. So you can continue working for both employers. No problem. Okay?
Okay. So that would not affect my H-1B condition?
No. See, as long as both jobs are in the major area of your education, you can do 2 jobs, 20 jobs, 50 jobs, doesn't matter. Okay?
Gotcha. Thank you very much.
You are welcome. Good luck. Okay, let me go on to the next person, and this one is Buffalo, New York. Let's see. Area code 716. Here you go. 716, I can hear you. Go ahead, please.
Yeah. So my question is actually a follow-up of the first question you got asked right now. So I'm in a similar situation where I'm on H-1B with an approved I-140 for a few years, 3-4 years, and I've got a job offer, and my spouse is on F1 OPT extension, right? So I'm planning to bundle the H-4 change of status and H-4 EAD for her,
Yes.
along with my H-1B transfer.
Sure.
So you mentioned it is possible, right? Now I've got 2 follow-up questions.
Of course.
So, so can her change of status be applied for a futuristic start date, like the end of her OPT extension period?
It's
That
funny.
is question number 1.
Right.
And
Go ahead.
Sure.
Keep going.
Second, she is currently employed. So when her change of status becomes effective, does her employment needs to be ended and restarted, or she can continue to work throughout the transition?
Okay. So let's parse these questions 2 different ways. Okay. First of all, can you file for H-4 with a future date? Yes. H-1s have a future date of no more than 6 months from when you file. You can't say, I'll start H-1 7 months from now. You can go up to 6 months. But H-4 does not have any such limitation as far as I remember. Okay. So H-1 could say, I'm going to start my H-4 is going to say, I can start my H-4 in 8 months or 9 months. I think that's possible. Okay. That's my understanding. It can be confirmed by your lawyers, but that's my understanding. Number 1. Number 2, the moment she receives a change of status, she ceases being on the old status. So let's say you say, I want start date to be 9 months from now. When the H-4 is approved, she would lose her F1 status and she'll go to H-4. But in the meantime, she will stay on F1. So could she continue working? Yes. Okay, what happens if they approve her H-4 by mistake starting tomorrow? Well, then she'll also get her EAD, right? So I'm not clear how the government would. My concern is, see, when the litigation was settled, there was an agreement entered into, and that agreement is publicly available. Your lawyer should review that agreement and make sure that having a contemporaneous start date is not a prerequisite to the approval under this bundling rule. I don't think it is. I have no reason to believe that it is. something to be double checked with the USCIS. Okay, because this is a one-shot deal. If you apply for premium and then you get approved premium and she gets stuck in the normal queue, not a big deal because you still have F1, but that would stagger the approval times. Okay, so bottom line, I think it should be possible to do a future date, but I don't know what the terms of the settlement are. I don't remember offhand. It should be double checked. Understood?
Got it. Thanks a lot.
You're welcome. Good luck. Okay, now let's see. So we have about 8 more questions. No big deal. Let's see. We are going to New York next. New York area code 917. Let's find 917. 917. Yeah, that's the one. Got it. 917. I think this is the one. 917, I can hear you. Go ahead, please.
Hi, Rajiv ji. So I do have a question around the high salary requirement for EB1A.
Sure.
So we need to show that I'm making more than the usual people in the field and I'm working in at a specific geography, right? So let's say I am in Chicago downtown and making 150K, which is 58th percentile according to OnDeck.com and SLC Data Center. And now, since I'm working remotely, I can go to middle of nowhere in Tennessee or West Virginia or maybe like outskirts of Illinois and be at 95th percentile with 150K as salary. So will that be okay or will that be a red flag for USCIS?
Well, this is out of the very messed up EB1A, this is the most messed up clause about the high salary. I'll tell you why. So just a few weeks ago, actually a few months ago, we did an O1 and then an EB1A for the same individual. She is a financial professional in New York. Okay, I think her salary was over 360, something like that. Now, even for New York salaries, that was a high salary. So I gave the comparison with the New York salaries. I showed that she was the top 5 percentile, if not 10. Better than 10, she was the top 5 percentile, something like that. Government comes back and says, no, give us national comparisons. That's the most idiotic thing they could do. Because under national comparisons, she was 1 percentile. Okay. So government is full of surprises. I don't know what they will do. If I were the government, so remember, EB1A does not depend upon a job. So I would say, here's my local comparison from, Little Rock, Arkansas. And here I'm considered to be the top 0.1% salaries. Certainly worth a try. Okay. But I'm forever surprised by what the government does in this area. Got it?
Yeah, so if I have to try that, is there a minimum period of stay I need to go into that town and live in?
I'm always uncomfortable when people try to game the system. I'm not saying that you are trying to do that, but it does sound like that. Why am I uncomfortable? Because somewhere in my head there is always the fear, being an immigrant myself and a US citizen far later, I always fear that the government can come back with some kind of a bad faith filing, saying that you just cooked up these facts to get through. Is it legal? I think so. Can they get at you? I do not know. Okay. So if I were you and I'm going to take that path, I would plan on staying there at least for a while, as long as I can. Okay?
Okay. Thank you, sir.
You're welcome. Good luck. Okay, let's go on to the next question. Next person who logged in was from Texas. Where in Texas? 469. Hang on one second. Add star, send to subconference, promote to host, unmute caller, place on hold, increase volume, decrease volume, drop caller. Okay. 469. Let's see if we can find area code 469. 469. 469, I can hear you.
Hello, Rajiv. So my question is, I'm on F1 student, F2 visa, which is expiring on October 2023 this year. I have a STEM OPT EAD card, which is
Okay,
expiring
hold on. Your voice is barely coming through. There's something messed up with the conference facility today, but yours is especially bad. Can you get closer to the mic and talk to me then? I heard that you are a student.
Yeah, I was just.
Much better. Go ahead, please.
Can you hear me?
Yes.
Okay. So my visa, F1 visa is expiring on October 2023 this year, and I have my STEM OPT EAD card, which is expiring on February 25. So my question is like, can I travel after the United States after my F1 visa is expired after October?
You can travel, but you can't come back.
Okay, I cannot come back.
You will-
So is there any way that I can get a restamp?
You'll
on
need to get
my
a
passport or something like
you'll need to get another visa stamp. And frankly, if I were you, I would think twice about it. I probably would wait until I get selected on an H-1B and apply for an H-1B visa in the future. But if you are the adventurous kind and want to take a chance, and the trajectory of your career has been quite clear, you went to a good school, maintained good grades, you've been a bona fide student, a good faith student, then you can try your luck. They might give it to you in an extension. So I don't know all the facts of your case, but no matter what you do, remember when you apply for a visa, you are taking a chance. Okay?
Okay. And
You're welcome.
here's the main thing that back this year March, I went to the India and I got engaged and needed to file for my wife. So like I got a court marriage, but ritual marriage is still left. So I was planning to go, but if it is not possible, then if I need to call her over here, like, can I file dependent file for her?
Yeah, I think so. Now remember, the government could always say, well, we'll give her an F2 visa once you get your F1 visa done again because the old one has expired. But they may not do that. They were not doing it until recently. In the context of H4s, they have started doing that now and then. So it's worth a shot. Have her apply. Let's see how it goes. Okay?
And there's a possibility that she can get her visa
Yes.
stamp for this year end, or as I have a February 25, like as EAD card is expiring.
Well, I don't know the answer to that question. If in February your EAD card is expiring, it's pretty close to the edge anyway. So I don't know. You can try, but I don't know how it's going to play out.
2025.
Oh, 2025, plenty of time then. Go for it.
EAD card.
Yeah. Then go for it.
Yeah.
Okay.
So, but her visa will be until February 25?
It should be. Coextensive with your EAD.
Oh, okay. So if I'm filing, it will depend on my EAD card, right?
Yeah.
Her visa depend on my EAD card.
Yeah. But you know what? Just double check.
Thank you.
Double check whether there is any special issues. Your DSO would know. Double check if there are any special issues in applying for an F2 while you are yourself on OPT. I am not aware of any. Okay.
Okay.
Good luck. All right. We have 6 more questions. Let's see. The next one is from, this is New York, area code 718. So let's go to area code 718. 718, I can hear you. Go ahead, please.
Hi, Rajiv. I just spoke to you a bit earlier. I just had a follow-up question to that case you are managing where someone from Europe is coming to the US as a director. So
Oh, yes.
I was just wondering, like, if, for example, he was the section manager in the US and then he went to Europe for a year and then he's coming back as a director. Now, if he wants to visit for some time in between that year-long period, does he come back on H1 or does he come back on another visa? That's
He
question
can,
one.
that depends.
Question
Hang on,
two
hang on.
is,
Stop. Let me answer this one first.
Sure.
So he can come on a tourist visa if he's just coming for a visit.
Okay.
But if he's going to come and work here, then he should come on an
Okay.
H1B. Remember, H1B can be used intermittently. So you can use H1B for 10 days under the terms of the H1B, then go back. So there's no requirement that H1B must be used long term. Go ahead. Next question.
So if he comes back and if he comes back using tourist visa, is H1B still intact or like it's still intact, right? Then?
It's still intact.
Okay.
Okay.
And when he comes back after a year, does that amendment need to be filed before he comes in, or does it need to be filed after he comes in?
It actually does not need to be filed at all if he wants to continue working as a unit manager. Because the green card job is supposed to be given to you only when
coming
you...
back as a director?
No, if he comes back as a director, you have to file the amendment before he lands. But if he's going to come back as a unit manager, then be
I see,
promoted,
I see.
then you can do the amendment after he comes.
Mm.
Okay.
I see. So the H1B should be consistent with whatever position he's coming in.
Absolutely. That is exactly how it is.
Got it.
Good luck.
Got it. And just the last question.
I'm going to have to move
sorry.
on. Listen,
Sorry,
I've got,
just the last question
I've got
I had.
other people waiting. Sorry.
Okay. No worries.
Yep. So I do need to cover as many people as I can. 5 more people. Let's see. Who's the next one? This one is from Texas. Texas area code 214. Just 1 second. Let me find you. Area code 214. 214, I can hear you. Please go ahead. 214. Area code 214.
Yeah, thank you so much. So I have a quick question. Actually, not quick. It's complicated because let's say I work for a company ABC, but ABC is the company that's on my W-2, but it's not the company who filed for my I-140 and the I-485. It was the parent company.
Okay.
And now the parent company had done some reorg, and then the company ABC I worked for was sold. So all the employees of the ABC now belongs to another company. And then my 485 has been pending for less than 180 days when the merger happened.
Okay.
I guess my question is, does the new company have to file another one I-140 for me, or like I-140 amendment? If yes, when would the 180 day start like counting after the new one I-140, or like just like when would the 180 days, would that affect the 180 day rule?
Okay. So first of all, how many days has your 485 been pending right now?
140, just 90.
Sorry, I didn't understand that. How many days?
90 days.
90
so
days.
It's
Okay.
about 100. Let's say just 100.
100 days.
Yeah, 100.
That's a choice
Yeah.
your lawyers
Yeah.
should help you make. If the conditions were right, I would probably not file an I-140 amendment. I would just wait for another 80 days and then just file an AC-21 supplement J. That way I don't have to do the I-140 again. That's something I would consider. Second thing I would consider is, do I really need to do an I-140 amendment? Because if I am if I'm a successor in interest, I should be doing an I-140 amendment. So the I-140 amendment is required with the change of companies. Okay. But if you are so close to the edge, 80 days, I don't know if I would do the amendment. I would probably just wait for another 80 days to pass. So bottom line is, even though the law requires me to file the I-140, it doesn't require me to do it right away. They should be, are you working on your H-1B or did you use your EAD?
H-1B.
Okay. They should transfer the H-1B unless they are successor in interest, then they don't have to do an H-1B amendment. Now that's a legal decision that they have to make. But 2 choices are there. to either file the I-140 or wait for the 180 days and just do AC-21. I tend to go with the AC-21. All right?
Okay. All right. Thank you so much.
You're
Really
welcome.
appreciate that.
You're welcome. It wasn't that complicated, so no problem. Good luck.
Oh, thank you so much.
All right, bye-bye. Okay, let's see. Who is next? Who is next? So we have 4 more people left to go. This one is from Ohio. Ohio, area code 937. 937, I can hear you.
Yeah, hi Rajiv, can you hear me?
I can, yes.
Okay. So I'm in my F1 OPT. My F1 will end in October 6th. So I have, I'm working for employer A and B. At the same time, both got picked in H1. So can I go ahead and apply for both, or
Yes.
do I have to just do one by one?
No, you can apply for both. I do not know of any reason why you cannot, as long as there is no collusion or relationship between the two companies. Can multiple companies fight for your H-1B? Sure, why not?
But in the stamping, what should I do? Should I stamp like
Well,
one, or
let me ask you this question. Hang on. Let me ask you this question. When your H-1Bs, both of them are approved, do you want to work for both companies or work for one company?
Yeah, I have a confusion about concurrent and the both companies.
Yeah, you
Probably
can do that.
Like to work for both.
Yes, you do. What you can do is you can choose one company arbitrarily, that this is the main company, and I'm going to file my H-1B as main H-1B through them. And then the second H-1B will be filed as a concurrent H-1B. Okay.
So for this, both employers should know that I am working for both companies.
Yeah, they should. Absolutely.
Okay.
All right.
My one more question is, so now employer B, I'm working for employer B. So in my I-20, I have both employer A and B. I don't think so employer A, I did ask employer whether I can work or not, but employer A said, you are on H-1B, which I am not. I'm in F1. So, but the HR thinks that I'm in H1, and now they have to file H1B for me. So is there any problem from employer A if they figure out that I'm working for employer B?
I don't know the answer to that question. I
Because
can
in
answer.
I-20
Hey, hang on.
application, both employers.
I can answer immigration law question. I can't answer questions about what companies are going to think. No idea. Okay.
Okay.
Good luck.
Okay.
Yeah, I can say if something is legal or illegal. I don't know if how the companies will react. Let's go to area code 914. That's New York. Okay, 914, I can hear you. 914, I can hear you.
Yeah. Hello, sir. I have a quick question. Actually, I got notice of intent to revoke after like 4.5 years.
Mm-hmm.
My first H1B got approved on consular processing, and I went to India for stamping in September 2019.
Mm-hmm.
And my project got ended in October. I came back to USA by that time.
Okay.
Maybe USCIS or consulate reached out to my manager maybe in November or so.
Okay.
That time she replied that he's no more working with us, kind of thing. So after like 4.5 years, I got notice of intent to revoke. Like I was more concerned since it is an initial petition. So does it impact my cap? Because that time I was in bench. After like 30 days, my employer placed me to another project.
Okay.
So I have like a 30 days gap. So my employer told we can keep that as leave of absence. And he responded. So what are the chances
This is a
of
little.
approval
This is a little.
income
Hang on. This is a little too complicated for me to answer without a detailed conversation with you. I can tell you the general law. Okay, see how it applies to you. So the general law is, if the notice of revocation gives you even, let's see, let me think about this for a moment. So if it is revoked for fraud or misrepresentation, then you are subject to the lottery. But if you have even 1 day past October, even you have October 1st, 1 day working, and they say revoked from October 2nd, you should not have a problem. We had a case like this recently, and we tested this out. So what happened was our beneficiary, a civil engineer, was working in location X, whereas she was approved for location Y. Employer didn't realize that they had not marked the right location. So when the USCIS went for site visit, they revoked the case, and we argued that this revocation doesn't take away her lottery. And they actually gave me that, and she went and got a visa stamp. We amended the H-1B, she got a visa stamp and came back. So something to be tested, I think. Unless the revocation is for fraud or misrepresentation, a case can be made that you are not subject to the lottery. Make sense?
Okay.
Good luck.
Yeah. During the time of interview, I have a project actually.
Look, I don't want to get into the facts. Look, I told you the law. I don't want to get into the facts. They are too complicated. I will not give you wrong advice. I can give you the general law. That's how the law should apply. Okay? Good luck.
Okay.
Yeah. Yeah. Some of the facts, I need to sit down and actually work them out. And that's a process. But overall, unless revoked for fraud or misrepresentation, we have argued, even if you revoke my H-1B, you don't take away my lottery. And it worked. Area code 706. No, what's the next one? There are only two questions left. One is from Georgia. That is 706. Georgia, I can hear you. Georgia, go ahead.
Hi, sir. I'm Bhargav. I'm currently doing my master's in agribusiness from University of Georgia.
Yes, sir.
And the thing is, mine is a non-STEM major, and no one is really willing to provide me, give me a job just because of the sponsorship thing. So my question here is, I've done my internship during my master's, and if at all I do a job for the next 1 year without a sponsorship, and is there a chance for me to start a day one CPT program since I already used my CPT earlier?
Yeah, see, I've had this discussion before. In my opinion, a CPT is like just doing a course. So if you were allowed to be a student, can somebody tell you that you can't take these credits? Because it's just like saying that. So in my opinion, you can take CPT again, no problem. Okay?
Okay.
Good luck.
Yeah. So I have one more question.
Mm-hmm. Go ahead.
So since mine is related to agriculture and business, mine is an agribusiness major, so can I work for an IT firm which deals with a business role, like a business analyst or something like that, and file for an H-1B from that role?
Doubtful, because I don't know your coursework. You should talk to your DS so they can tell you whether it's related or not. Okay?
Okay.
Good luck.
Sure. Thank you so much. Really appreciate it.
Very welcome. All right. We did good on time. Last question is from California. California, go ahead. California.
Hi, good afternoon, Rajiv. Hi.
Hello. Go ahead, sir.
Can you hear? Hello?
Yeah, I can hear you. Go ahead, please.
Hi, Rajiv. I have a I-140 and my I-485 were filed last October. My question is, will the 180-day rule for AC-21 to kick in the day it was filed or after I-140 is approved?
Okay, so that's a very interesting question. And the way this works is, listen to the language of the regulation. The regulation says, I-485 is pending 180 days and I-140 is approved. So it is not serial. It is not first I-140 is approved, then it is pending 180 days. So the idea is, if I file your I-140 485 today, after 100 days, your I-140 gets approved, you need to wait only another 80 days. Okay? Got it? So
Okay, so it's from the date of I-485. It
date
doesn't
of
matter what I-140
exactly,
approved or not.
exactly.
That's understand.
All right.
Okay.
Good luck.
And I have one follow-up question. Like my I-140 is approved now in February last February,
Okay.
2023. But my first name is missing in that. Will it delay any in my I-485 EAD or AP advance parole processing?
I don't think so, but mistakes should be
The approval
corrected.
notice.
I don't think so. It should cause any major issues, but these things should be corrected. And if it is a government error, they should correct it at no cost to you. Okay?
Yeah, my attorney, they asked USCIS for a corrected approval notice, but I'm just waiting on that. I wanted to. And if I, based on, so since my AC-21 kicked in, if I have to relocate for H-1 transfer, is that fine at this point?
Ask your lawyers to answer that question.
On AC-20.
Ask your lawyers to answer that question because it depends upon the terms of your labor cert and the intention of your employer. But once AC-21 kicks in, then whatever you do, as long as the jobs are same or similar, you can be relocated anywhere. No problem at all. Okay?
Got it.
Good luck.
Thank you so much.
You're welcome. Somebody else has just raised their hand. Let's see. This one is from Texas. Yeah, Texas, go ahead. I can hear you.
Thank you, sir. I wanted to know what visa do kids get if I-140 EB1C is approved. What are the forms involved and tentative time we are looking at?
What is approved? I-140? What is approved?
EB1C.
EB1C is approved.
I-140 EB1C category.
Okay. So what visa do kids get? They don't get any visa just because I-140 is approved. Okay. But the fact that it's under EB1C, are you still maintaining L1 status?
No, sir.
Okay.
I got my EAD and the advance payroll on 19 July, and I'm expecting approval sometime in April end or early May.
They don't get any visa until your EB1C is approved. Then you can request that the file be sent to the consulate, where if the children are under the age of 21, they will interview and get their green cards. Okay.
Do we have to file any forms for this, sir? Additional forms?
You have to talk to your lawyer. I-824, I believe, unless they have been mentioned in the petition paperwork already. So I don't know how your paperwork was filed. Okay.
Okay, so one question, technical question is when my EB1C was filed in 2021, my eldest son was 20 years old.
I'm not gonna get into CSPA calculation on a phone call. So that calculation has to be made by your lawyers, not by me. All right. Good luck.
Thank you, sir.
You're welcome. Last question, also from Texas. Texas, go ahead, please.
Yeah, sorry. I have a quick follow-up. So is my I-140 still valid if the company that filed the I-140 actually filed for Chapter 11 bankruptcy?
I don't know the answer to that question. A lot depends upon what kind of, you said Chapter 11 bankruptcy. I do not know if that survives. So that becomes very complicated. The answer is, I do not know. It is complicated. Talk to your lawyers. If you reach the AC-21 180 days, you might be okay. All right? Ma'am, good luck.
But not at the time when it filed for bankruptcy.
Not at the time when they filed.
That's the time I have to meet the 180
Well,
days.
it should not be an automatic revocation. In other words, just because they filed for bank, you're still getting paid, right? You got paid all the way through?
Yeah.
Yeah. So I think you're reasonably safe, but now it became complicated. Before it was not complicated. Now it is far more complicated. I can't give you advice over a call like this. You should talk to your lawyers, have them go over the facts, make sure you are protected. But it looks like they should be able to find a way out for you. I had a company like this that went into bankruptcy, but they were under reorganization, Chapter 13. So that we were able to survive, and we were able to get the green card. Okay? Good luck.
I think that's the reorg one is Chapter 11, right?
Yeah,
Not
that's
the-
what I said.
11.
That was a Chapter 13 reorganization.
That's the
Yeah, so I don't
Yeah.
know the answer to that question. It depends upon how things are set up. All right? Good luck.
Got it. Okay.
All right, bye-bye.
Yeah. Thank you.
All right, folks, I'll see you next week. We'll do a LinkedIn audio call. It's good to always hang out with you. Take care, everyone. Bye-bye.